Okay, Kentucky revised statutes, oil and gas conservation. 591, purpose and application of Kentucky regulation, Kentucky revised statutes. 591, purpose and application. Purpose of Kentucky Revised Statutes 353, 592 to 593 shall be upon the delegation authority to administer the underground injection control program under Section 1425 of the Safe Drinking Water Act. To put underground source of drink water to prevent danger of Class 2 wells, Kentucky Review Statute 592, 593 shall apply to a person defined in 353, 510 to all lands, include federally owned lands, to all Class 2 wells without regard to the time of the well was drilled, provided that the department make reasonable distinction between existing new Class 2 wells. Implementation Kentucky Revised Statute 353, 592 and 593. Number provisions of Kentucky Revised Statute 353, 592 or 593 shall apply to crude oil or natural gas production wells that are not Class 2 wells. Alright, powers and duties 592. In addition to the powers conferred by the Department of the Kentucky Revised Statute 353, 500 to 720, with the notwithstanding within provision of 500 through 720, the Department is authorized, obligated to develop and promulgate regulatory program purpose for accepting primary responsible administrator of the Underground Injection Control Program under Section 1425, Safe Drinking Act. The end of the department shall include the regulatory program developed and promulgated under this provision. Regulations regarding drilling, casing, operating, plugging, construction, conversion, maintenance, abandonment of Class 2 wells, protect underground source drinking water, prevent endangerment. Regulation prohibited underground injection Class 2 wells except for the authorized such regulations by permit issued pursuant thereto. 3. Regulations requiring owners operator Class 2 wells to demonstrate financial responsibility. Cost closure of all Class 2 wells to demonstrate the financial responsibility but not included, not to be limited to well plugging bonds required by KRS 353, 597 and 12. Regulation providing the responsible public notice application permits of Class 2 wells, providing public participation, issuing such permit. Regulations establishing schedule fees, mechanical integrity testing, periodic registering of Class 2 wells to be paid to owners and operators thereof. The schedule fees shall be made based upon reasonable cost of the Department administering the underground injection control. Regulations may provide with a collection fee prior to delegation authority of Federal Environmental Protection Agency, which shall be refunded to the Department if the department does not receive said delegation. No regulation promulgated pursuant to this section shall authorize endangerment of underground sources of drinking water or be stringent with the regulation promulgated by the Environmental Protection Agency pursuant to the Underground Injection Control Program. Safe Drinking Act, Title 42, U.S. Standard Code 300F, 10th sequence. Or appeals office of administration hearings appeals may be taken off of the final order the department issued, denied, modified, by the revoked permit. Underground injection control program appeals should be taken with the cabinet office of administrative hearings. 595. Notice to surface owner of the intent of the drill, oil, or gas well compensation for the damage surface restoration surfaces. The person in this section means a natural person, corporation, firm, partnership, venture, receiver, the trustee, or executive, the administrator of the garden, fiduciary, or other representative of any kind that includes any of the government, political, subdivision, agency thereof. Drilling operator means for the drilling, deep conversion over the well, oil, and gas production, core hole, oil, gas purpose, the drill hole for the stratigraphic test for the oil purpose. Entry means moving over the surface of the land with equipment commencing with the drilling operation should include the entry with a survey and with the asserting identification well location. Operator means with the person who enter or not, whether the owner or not applies over the holes of permit drill operation, as the principal on the bonds permit for the well to be issued by the department. Surface owner means the person whose name and the surface of the land the drilling operation contemplated to assess for the purpose of this action, both according to the record of the proper evaluation administrator of the county, where the land is certified by the proper evaluation administrator. Proper production operation means the operation of the well, production, oil, or gas, include all acts, structure, equipment, and roadways necessary for the operation. New well means a well that is spudded after July 13, 1990, does not utilize any part of the well. The drilling location existed prior to July 13, 1990. Completion of the well, meaning for the completion of the process necessary before production occurs, including the laying out of the flow line for the construction of the tank battery. The well is not productive of the day of the completion of the well shall be day is plugged and abandoned. To this section shall be applicable for the drilling operation new wells, except for the providing subsection 7 of the section shall not apply for the reworking of the well. This section applicable only when the surface owner does not consent with the drilling operation, and there has been a complete severance of the ownership of the oil and gas from the ownership of the surface owners or interest of the oil and gas prior to commencement of the drilling of the well. The operator shall give the written notice for the surface owner of the operator intent with the commencing drill. In the operation, operator shall have the purpose to give the notice secure for the property value of the administrator all of the one within 90 days of the given prior giving of the notice certification shall identify the person whose name of the lands showing operation commence with the asset of the time certification is made with the rate and certification made by the property valuation. Administrator of the surface ownership will be conclusive of the evidence of surface ownership. Notice required to be given the operator surface ownership will identify with the following locate proposed entry for the surface drilling operation day after which the drilling operation shall commence. The photocopy of the drill application department of the well to be drilled. Name and address the telephone number of the operator after the discussed surface ownership of the matter set forth in subsection 4 of the section of the commencement of the drilling operation. If the surface owner elects to meet with the operator surface ownership of the request of the operator schedule the meeting in a mutually agreed in time place with the limitations set forth herein, failure to surface owner to contact the operator at least 5 days prior to the proposed commencement of the drilling operation, inclusive of the deemed of the waiver of the right to meet with the surface owner of the meeting shall be between the hours of the 9 o'clock in the morning and setting over the sun of the day, same day, at least 3 days prior to the commencement of the drilling operation, unless agreed upon to otherwise place shall be located within the county where the drilling operation commenced with the operator and his agent with available to discuss surface owner and his agent matters set forth in subsection 4 of this section. The notice shall be given the surface owner either the certified mail address, surface owner address showing of the certificate, obtained property valuation administrator, which is postmarked at least 10 days prior to the commencement of the drilling operation, post delivery surface owner the last 8 days prior to the commencement of the drilling operation. Notice surface owner is defined in the section should be deemed conclusive of the notice for the record owners of all interest in the surface. Operator and his agent shall, if surface owner accepted his offer to discuss, be available at the time agreed date and place to discuss surface owner of the following place of the roads to be constructed by the operator place to entry upon the surface of the drilling operation construction place instrument of pitch used by the drilling operators, restoration fences to be cut in order to make entry upon surface of the drilling operation, use of the water, surface of lands, remove of the trees, surface of water drainage change if it is caused by the drilling operation, surface owner shall be entitled to reasonable compensation operator damage grown crops, trees, shrubs, fences, roads, structures, improvements, life jack thereon and can cause by drilling a new well. The surface owner should be entitled to the reasonable compensation for the operator for the subsequent damage growing crops, trees, shrub fences, road structures, improvements, and livestock caused by subsequent production of operations for the operator thereon. The surface owner should be entitled to the reasonable compensation for all negligent acts of the operator measurable to damage the productive the capacity of the soil. In addition, the operator shall not utilize any more of the surface of the state with a reasonable than necessary for the exploration, production, and development of the mineral estate. The compensation required pursuant to subsection 5 of this section shall be paid in the manner of the mutually agreed upon operator surface owners wrote with the failure to agree upon make with the compensation required shall not prevent the operator commencement of the drilling operation. Operator shall send with the surface owner payment about a check with a draft in accordance with the provisions section no later than 90 days after the completion of the well. Surface owner remedy with the action compensation circuit court in which the lands of the greater part of the are located with the drilling operation were conducted the operator for to tend payment within a 90-day period, or if the tender is not reasonable, surface officer within intending for the reasonable compensation provided in this section, as well as the attorney fees. If the operator relies on third-party appraiser, the assessment of the damage should be no award of the attorney fees. In conjunction with the plugging and abandonment, any of the well reworking, and the operator will restore the surface improvement thereto with the condition in the near practical for their condition commencement of the work with surface owner and operator may waive the requirement of writing subject to approval of the Department of Waiver in accordance with the administrative regulations. 8. Nothing in this section is construed with the diminution of the rights of the operator and surface owner that exists for the established common law with the compensated pay with the accepted pursuant of the provisions subsection 5 and 6 of the section shall be complete bar to assertion of any other remedy for such damages. Alright, 597, the replacement disrupted water supply by well operator. Well operator shall replace water supply owner of the interest real property while obtaining to all parts of the supply of water, domestic, agricultural, industrial, or other legitimate using underground surface source where the supply has been substantially disrupted by contamination, diminution, interruption, or approximately resulting from operator's oil and gas operation. 600 has been repealed. 610. Conditions under which permits may be issued exemptions. Except for providing Kentucky Revised Statute 500-720, no permit shall be issued for the drilling, deepening of the reopening and shallow well production or within the left of the proposed location of the well shall be at least 330 feet from the nearest mineral boundary premise upon which the well is to be drilled, deepened, and reopened. The proposed location must be at least 660 feet from the nearest oil-producing well. The subsection does not contribute to regulate the distance between the well that do not produce oil from the same pool. Except for providing Kentucky Revised Statute 500-720, no permit is issued for the drilling, the deepening, reopening of the shallow well of the production gas unless proposed location of the well should be 500 feet with the nearest mineral boundary of the premise upon which such well is drilled, the deepened, and reopened. The proposed location for the most least of 1,000 feet of the nearest gas producing well of the subsection should not be contributed to the regulating of the distance between the well that do not produce gas from the same pool. This section shall not apply with the wells drilled, the deepened, and reopened with the injection water, gas, or with the other fluids or oil gas producing formation to any of the drilled, the deepened, and reopened the pool of the portion thereof of which include the secondary recovery program commenced and proposed if the proposed location well conform with the geometric pattern already established on all premises which offset with affected by the wells. The well drilled, the deepened, as well water supply well, the geological structure testing holes to premise for the limit of the incorporated activity and acts here of the ordinance regulating location spacing of the well production oil and gas distance not less than the distance prescribed in the section. To wells production oil drilled, the deepened, and reopened, complete with a depth of at least 2,000 feet. There are no workable bed coal or lesser depth of formation of the oil expected to extract with no appreciable affected by factors determined by the convention of the natural drainage. Location of the wells for production oil coming from the exemption at least 200 feet with the nearest boundary of the premises of which the well is to be drilled, the deepened, and reopened. The proposed location must be at least 400 feet with the nearest oil producing well. This subsection does not contribute to regulate the distance between the wells which it do not produce the same from the same pool. 0610. Alright, variance for requirements of the Kentucky Revised Statute 610 reviewed under Kentucky Revised Statute 353-700. Notwithstanding with the Kentucky Revised Statute 353-610 with the application submitted with the permit with the drill, with the deepen, with the reopen, the close, with the boundary, with another well, with the described in 353-610. Application is accompanied with the written consent of the owners and oil gas into the distance prescribed in 353-610, which will be offered at proposed well with the department shall issue for the permit of the well. Notwithstanding Kentucky Revised Statute 353-610, with the application submitted with the permit of the drill, the deep, and will reopen the well with the closure of the boundary with another well with the prescribed in the Kentucky Revised Statute 353-610. Director determines after the notice of the owners of the oil and gas into the distance described in the Kentucky Revised Statute 610 with the topographical or the factor of the delineated subsurface geological map of the reservoir analytical data made compliance with the requirement of Kentucky Revised Statute 353-610 and unduly burdensome with the conflict with a reasonably prudent method of practice of the production of oil with the gas department may issue the permit for the well. Applicant may include, but not limited to, the core analysis, geophysical, electrical log data, reservoir pressure analysis, other information demonstrating the satisfaction or directly such relief is warranted. Another thing withstand the Kentucky Revised Statute 353-610 with the department shall issue for the permit as well to be with the deep drill, with the deep, and the reopen, and with the close with the boundary prescribed in the Kentucky Revised Statute 610. If a pooling order is issued pursuant to the Kentucky Revised Statute 353-630, if the permit is issued for the drill, the deep, and the reopen the well under Section 1 and 2 of the section of the location close with the well and boundary prescribed in the Kentucky Revised Statute 610, the permit a like variance required in the Kentucky Revised Statute 353-610 when all permits officers that are adversely affected by the well. 5. In an order of final determination for the department under this section shall be the subject of the review in accordance with the Kentucky Revised Statute 353-700 and the administrator of the regulation promulgated thereunder. Alright, 630, pooling and oil gas interest. Pooling and oil gas interest conditions are reviewed under Kentucky Revised Statute 353-700. Whenever there's a separate tract of the land situated because of the side of the other condition that doesn't contain the location well of the oil gas, reeve the drill with the deep, with the reopen, the reeve the spacing provision. Kentucky Revised Statute 353-610, when the department shall order the after notice of the required with the given the notice opportunity with the commitment, and with 30 days of the date shown on the postal service approved in the mail with the notice of the publication 30 days of the day of the publication pulling with the oil and gas into the separate tract of the portion with all interest of the contract, continuous track of the portion thereof with the necessary for the pool tracks, one with the location of the drilling, deepening, reopening well with the production of the oil and gas compliance space requirement of the Kentucky Revised Statute 500 to 720. Department shall require the development and operation pool acreage and single leasehold as stated with according to the regulation rules promulgated in Kentucky Revised Statute 353 500 to 720. Whenever the other purpose of the drilling, the deepening, the reopening well, the location required with the pooling, except for the track for the interested in order to comply with the spacing requirement of Kentucky Revised Statute 610. Operators secure the written consent with agreement of the owner to lease 51% of the interest in the track, each for the track with a portion thereof, including the approved pooled acreage. Department shall, with its stand where it finds the requirements of subsection with the have it met with the order notice that is required to give it the notice opportunity with the commencement comment within 30 days with a shown with a postal service proof of the mail with which with notice to provide publication 30 days over the day of the publication pooling of the oil and gas interest in all tracks. Pollution is there, including proposed pool acreage established spacing requirements and Kentucky Revised Statute 353-610. Pooling orders should be made only after the applicant provides notice to all person reasonably known to oil and gas interests in any of the track portion of the proposed to be pooled. Purpose of section known and locatable owner if deemed with the consent of the degree of the pound pool provided with the operator comply with the publication requirements. Kentucky Revised Statute 353-641. Respectfully unknown with a non-locatable owner of the department shall issue the permit drill with the deepen, reopen the well with the require the development and operation pool acreage as a single leasehold of the state of the with the Ministry of the Regulation promulgated under the Kentucky Revised Statute 500 to 353 500 to 720. Whenever operating proposed of the drill, the deepen and reopen the well location on the wood require the pooling entry for the tracks in order to comply with the space of the requirement of 353 610. Operator owning the control of the right to develop the oil and gas underlying 100% of the inch of each of the track or portion thereof, including the proposed pool acreage of the department shall find that the requirements subsection have been met. Ordered after notice of those required to give the notice opportunity with the commencement of 30 days after the date shown on the postal service proof of the mailing. When the notice is provided with a publication of 30 days with the publication of the pooling of the oil and gas interest of all of the track portion thereof, including the proposed pool, the acreage established spacing requirement. Strictly advised Statute 353-610 of the pooling order should be made only after the applicant provided the notice of all the person reasonably known to all of the oil and gas interest in any of the track portion proposed to be pooled. For purpose of this section, unknown and non-locatable owners should be deemed to have the consent with the agree with the pooling provided the operator has complied. Publication requirements set in Kentucky Revised Statute 353-641 with respect to the unknown non-locatable owners of the department shall issue the permit to drill with the reopening of the well with the requirement of development and operation all of the pool track. A single leasehold as stated with according to the administrative regulation promulgated in Kentucky Revised Statute 353 500 720. No pooling is permitted by this section should be ordered, but the application filled with the drill to deep and then reopen the well with the medicinal limitation prescribed in the Kentucky Revised Statute 353-610. Leaser and owner of the oil and gas interest of the track shall request the pooling. No portion of the permit is section of the should be ordered with respect to any track with the point and portion thereof of the palm of the drill with the deep and the reopen. Unless the pooling was requested at the commencement of the drilling with the deep and reopening the well with the leaser owner of the oil and gas interest of the continue with the track pursuant with 1, 2, and 3 of this section. Unless the request is made with the owner of the opening interest to elect the participant the risk of the cost of the drilling with the deep of the reopening with the well with the company with the bond other status security satisfactory to and amount with the set with the director with the payment of such owner share of the cost of the drilling and deepening reopening of the well. Production of any well which is ordered to pool under the Kentucky Revised Statute 500, 353, 500 to 720 shall be the team with all purpose to have them produce each track with a portion will include the pool portion with the amounts established in pooling order. Specifically, any final order or final determination of the department under this section shall be subject to the review in accordance with Kentucky Revised Statute 353, 700 to Ministry of the Regulation promulgated thereunder. And that was 630. 353-640 pulling order notice provision surrendering share of the interest limited partnership review on Kentucky Revised Statute 353-700. Operator shall provide a list of the department and all persons reasonable to know with the oil and gas interest in the track, any track with a portion of the proposal of the pool of the application department, the pooling over the pooling order should be due only after the applicant provided the notice of all the person reasonably known to unknown with the oil gas interest in any of the track portion of the air proposed to be pooled in the event with the following application pooled under with the Kentucky Revenue Statute 353-632 with the unknown owners of the non-locatable owner of the operator shall call for the public no more than 30 days with the submission application on the pooling one notice of the newspaper with the largest circulation in each county. which any truck with a portion proposed with the pool is located with notice shall state the application for the pooling order is being filed with the division, describe the track with the portion of the proposed to be pooled. In this case, the owner is identified with the name of the last owner. In this case, the non-locatable owner identified with the owner and the owner of the last known address. State with the party with the claiming the interest in any track with a portion thereof of the pro of the pool should contact the operator published address. Provide with a copy with the notification director within 20 days of the publication. The applicant shall prove the notice of the division concurrently with the application. Pooling order shall authorize the drilling, deepening of the reopening of the operation of the well, production of oil, gas for the track with a portion of the pool shall be designate the operator drill with the operator of the well shall prescribe the time and the manner in which all of the owners operating into the pool track with a portion of their being may be elected to participate therein, provide with all the reasonable cost expense for the drilling, the deepening, the reopening, and the completing, operating, plugging, and abandoning wells shall be borne with all the production of the well shall be shared with all the owners of the operating interest of the portion of the new net mineral acre of the pool tracks under lease. Each owner shall make with a provision payment a reasonable act of the cost of the include with a reasonable charge for the supervision by all those who elect to participate therein. A pool owner order shall be established. Procedure owner and operating interest that does not decide to become participating operator to elect either surrender by means of sale of the lease interest of the participating operator on a reasonable basis with a reasonable consideration, which is not agreed upon shall be determined by the director share of operation of the well non-participating operator on a carry basis to proceed allowable to his or her share equal to 200% of the share cost of to his interest. An owner and gas owner who identify the location remain unknown for 30 days has passed over the day of the publication required in subsection 1 over this section with the of the pool of the Kentucky Revised Statute 353-633 with the deemed to have elected for the lease of the interest of the oil and gas operator exclusive 1/8 of the production attributable to unleased interest should not be entitled to make the election established in subsection 3 of this section, except as provided in this section. Oil and gas owner who does not make the election under the pooling order of 30 days for the entry order shall be deemed to have leased of the oil and gas interest for the oil and gas well operator manner established in the subsection 4 of this if the holder of the operating interest have obtained the interest of the lease of their granting right to conduct any one of the holder when the oil and gas estate of the owner and operating interest that does not make an elect under the pooling order holding the operating interest of the deemed to have elected with the sharing of the operating share of the well participating non-participating operator carry basis after the proceeding allocable his or her share of the 200% of the share of the cost allocable to his interest. Personal interest of the subject of the oil and gas lease, the arrangement of the grants, and another right to object to the conduct of operations shall not only own operating interest for the purpose of subsection 3. 7. The department shall provide with a pooling order into the Kentucky Revised Statute 353-500-720 required by the notice. Certified copy of the pooling order shall be recorded. Operator of the office county clerk of the counties with which any of the portion pool track is located recorded in the order from the time of lodging of the order of the for the record shall deemed to be delivered ordered to all known non-locatable owners. Any order of final termination of the department under this section shall be subject to the review in accordance with the Kentucky Revised Statute 353-700 and administer of the regulation promulgated thereunder. Alright, 353-645 Operation Development Unit Oil Gas Interest of Pool and Pool's Application for Unit Hearing Utilization Order Review under Kentucky Revised Statute 353-700. Section applied by any lease of the owner of the oil gas interest of the proposed interest of the department of the own discretion upon the application of lease of the owner oil gas interest of the pools and pool of the proposed of the after the notes of the leases of the owners of the oil gas of the interest of the pools and proposed of the units and used to issue an order of operation of the development unit of the pools or pools of any portion of the production or of the associated in gas in order to contribute the ultimate recover the utilization or operation of the development to each of the owner pools and pools shall have the opportunity to cover the fair and equitable share of the recover the oil and gas for the unit department that may recover the reasonable application fee to the leaser of the owner and oil gas interest applying with the proposed unit. Application of the unit shall include with the description area that be include with the unit of the map attached with the description pools portion and include with the unit statement of the nature of the unit operation contemplated a proposed allocation production reserve among the separately owned with the track with the interest of the contributed unit with the reserve of all of the calculated industry standard with the methods for the geological and engineering data determined to be appropriated by the department. Department may require the independent third party to verify calculation proposed allocation production reservoir of the procedure upon which of the wells and equipment separately owned with the trust tracks and interests is to be used in compensated with the unit operation documentation application approved with the 51% of the ownership of the interest of the proposed and including the unit. After note of the manner established within the unit in this section of the department shall issue the final order establishing unit the requiring unit in the development of applying with the utilized operation of the development of the pools or pools, any of the portion thereof, production of the oil and associated gas rebuild necessary in order to effectively carry out the operation at hand with the recovery included but not limited to increase the density of the drilling of the secondary recovery operation, pressure maintenance, repressuring, cycling, water flooding, territory recovery operations. Any combination of these in order to substantially increase the ultimate recovery of the oil, associated gas from the pools or pools within the unit to protect the correlated with the rights of the effective mineral orders. The value of the additional recovery of the oil and associated gas exceed the estimated additional costs incident to conducting operations or unitized operation of the pools of the unit will prevent waste, protect correlated rights of the owner in the pools or pools within the unit. Each well is permitted to drill, to deepen and reopen the converted injection well of the operating unit shall conform with the spacing standard established in Kentucky Revised Statute 353-610. The other unit spacing established for the department. All units operating production shall be deemed the all-purpose of the deduct of all the operation production up to each separately owned tract the interest of the unit utilization order in accordance with the section authorized with the unit operation pools or pools including drilling, deepening, reopening, conversion, injection well of the operating all of the wells and with each unit production oil gas for the unit designated the unit operation appropriate unit agreement provide allocation production reserves among all separately owned tracts and interest of the unit provide proportionately allocation of all of the reasonable cost expense of the unit operation with the cost expense are set out and prove the operating range cost expenses shall be allocated among participating owners operating interests elected to participate with the production separately owned tracts and interest share of the production of the unit. 5. Establish spacing approved from the unit. And 7. Any unitized order that shall provide justified equatable alternatives where the owner operating interest does not elect to participate with the risks and costs of the developing a unit that may elect with the surrendered interest of the portion to the participating owner reasonable base for the reasonable consideration if not agreed upon shall be determined by the department. Elect to participate in the development of the unit with a carried base of the term condition with a not agreed upon with the determinant of the department over the draft of the reasonable of the dispute arrive at the cost operating development unit with the department to determine a portion cost for 90 days after the date written department of the existence of the dispute without any person disposing disputing actual proposed expenditures shall file with the notice of the disputed cost 1 year after the notice of the actual proposed expenditure for the receipt of the personal filing dispute. In order establishing unit modified, altered, extended, or vacated, or otherwise amended with the department after the notice prescribed in this section demonstrate the effect of the person significant change with the circumstance supporting the amendment. An amendment extended the enlarged unit shall be arranged upon a written documentation owners with at least 51% ownership in the interest of the pools and pools unit. An amendment unitization order of the enlarging unit shall allocate each of the tract interest unit with an amended with a portion of the total production oil and gas well of the unit is own large portion of the contributing tract with the interest of the during with the remaining course of the unit operation supersede with the lieu of the allocation production provided for the any previous established unit have an effect for the date for in order. Well drilled, deepened, and reopened with the injection water gas out of the fluids within subsurface formation governed applicable state and federal statute regulations. Order final determination of the department of the section shall be subject to the review in accordance with Kentucky Revised Statute 353-700 and the administrative of the regulation promulgated thereunder. Alright, 353-650, exclusion of royalty interest for the computing share of production. If one or more of the owners of the operating interest of the portion of the pool tract shall the drill with the deep of the reopening operated pay with the cost of the drilling with the deep of the reopening operating of the well benefit another and of the interest of opening interest to provide with the pooling order. Such owner and ownership of the entitled to receive the share of the production tract of the portion therein of the pool accruing the interest of the touch for the other owner of the exclusive of any of the royalties reserved in the lease of the such tract of the portion exclusive of the 1/8 of the production attributable to all unleased tracts of the portion thereof until the touch of the proceeds equal to sum payable to by charge or interest other than the owner plus the reasonable charge for the interest of such funds. If the dispute arrive with the cost of drilling, deepening, reopening, operating well, the director of division oil and gas shall determine the portions of the cost. Alright, 353-651, vertical, horizontal, deep well, the establishing regulation of the drilling units pulling interest exemptions. Following provision of section administrative of the regulation promulgated, presuming that there shall be applied with a vertical deepening well, with a horizontal deep well, with an interest drilling unit with a vertical deep well. Commission shall, after the notice of the conduct with accordance with the Kentucky Revised Statute, Chapter 13B, with the regulate with the drilling location with the vertical deep well with a pool with the production thereof to prevent reasonable avoidable net range For each development unit, the drainage which is not equal over the counter drainage over each of the unit pool is to have the right opportunity to recover his or her equitable share of the recovery oil and gas pool. The prevention of waste protect with the enforced garage stay with the right to own the pool to avoid the augmentation or accumulation risk of the rising from the drilling of the excessive number of wells. The Commission shall, after notice for the hearing to be conducted in accordance with Kentucky Revised Statute, Chapter 13, B. Establishing drilling units of vertical deep wells. Each pool spacing vertical deep wells provided oil gas field with the covenant with administrative regulation promulgated with a particular field with the other administrative regulations promulgated by the Commission. Vertical deep well drills are not covered by a special field administrative regulation shall be governed with the administrative regulation promulgated with the Commission. Order of the Commission issued with a hearing. Each of the vertical deep well permitted with the drill of the drilling unit shall be the drill in accordance with the administrative regulation promulgated by the Commission. The spacing pattern fixed with the Commission well in the pool of the vertical deep is located applicable to any exemption reasonable and necessary for the instrument of the corner of the ministry of the regulation promulgated with the Commission. Unit is partly outside of the pool. Some other reason very well otherwise located unit would not be likely to produce for the paying quantity of the topographical conditions such as the drilling, the location under the burdens and other similar cause. Whenever an exemption is granted, the Commission shall take with the action offset with the advantage of the persons granted with the exemption may have the owner's right by reason of the drilling of the well exemption. No drilling in the unit shall be established if the Commission smaller than the maximum area of the drain efficiently one vertical deep well to produce the reasonable maximum recovery of oil and gas in the area under the exemption of the granted to the corner of the Ministry of the regulations promulgated by the Commission. Order establishing the drilling in the vertical deep well modified with the extent of the amendment vacated by the Commission after notice hearing with the prescribed above. Drilling units horizontal deep for the prevention of the way for the protection enforcement correlated rights owner of the pool of the Commission after the notice of the hearing conducted in accordance with the Kentucky Revised Statute Chapter 13. B. With administrative regulation commission establishing drilling unit with the horizontal deep of the drilling units based on the information provided with the request of the Commission. Each horizontal deep well permitted with the drill of the drilling unit established Commission shall be the drill in accordance with the administrative regulation promulgated by the Commission. Any order of the Commission established a horizontal deep well unit on both terms of the fair, reasonable, equitable, and necessary for the proper to protect with a safeguard respectful of the obligation of the working interest owner. Role of the owners based on evidence before the Commission. Pooling interest of the drilling unit through a more separately owned track with the embrace for the drilling of the unit where they are separately owned in all parts of the drilling of the interest. But person may pool with all track with the interest of the development operating with the drilling unit with the absence of voluntary pool of the upon application of the operative they have the interest of the drilling of the unit and with the after the Commission have given the notice to all of the person reasonable known to own an interest of the oil gas drilling unit after they have been conducted in accordance with the Kentucky Revised Statute Chapter 13B. The Commission shall enter the in-ordering pool in all tracks interest of the drilling unit, the development operation thereof, the inch for sharing with the productions therefrom. Each pooling order shall have upon terms and conditions which are just and reasonable. All operating included but not limited to the commencement of the drilling of the operation deep well upon a portion of the drilling unit which the pooling order has entered the show of the team and the purpose of conducting of the operation upon each separately owned track of the drilling unit by several owners thereof. The portion of the production allocated with separately owned track with include the drilling unit shall, when produced, be deemed all of the purpose have actually produced for the track by the deep well drilled thereon. Any pooling under the provision subsection 3 shall be authorized the drilling operation deep well production oil with the gas for the pool acreage shall be designated for the operator and drill operate the deep well shall prescribe the time and the manner which all of the managers operating into the pool track with the portion tracks may elect to participate therein to provide all reasonable costs expended for the drilling, completing, equipping, operating, plugging, and abandoning of the deepening when well shall be borne, all productions therefrom shared by all owners operating interest portion of the acreage pool tracks owned under lease. Each of the owners shall provision for the payment of the reasonable costs, include the reasonable charge of the supervision for interest past due accounts by all those who elect to participate therein. Upon application, any operator having the interest of the drilling unit, the person selected to drill operate the deep well shall be determined in competitive bids. Upon request, a pooling order shall provide with a just equitable alternative whereby the owner with the operating interest does not elect to participate with the risk of the cost of drilling deep well, but elect to surrender his interest portion of the participating owners on a reasonable basis for reasonable consideration, which is not agreed upon, shall be determined by the Commission on the participating in the drilling of the deepening well limited to carry base for the term condition, which, if it is not agreed upon, shall be determined by the Commission just reasonable. If an operator with the owning of the interest of the pool drilling unit and elects not to participate in the risk of the drilling of the deepening well thereon, another operating owning interested therein shall the drill and operate and pay the cost of the drilling operating deepening well provided with the Commission under the operating owner shall be entitled to share of the production of the track, the portion accruing with the interest of the non-participating owner, exclusive of any of the royalty, overriding royalty reserved in lease assignment of the therefore agreements relating to thereto the tract portion of thereof, exclusive of the prevailing royalty production attributable on the lease tract of the portions until the market value of the non-participating owner's share production, exclusively of the royalty, overriding royalty, prevailing royalty of production equals 3 times the share of the cost payable to pay by charge by interest of the non-participating owner. If a dispute arrive at the cost of the drilling opening with a deep well, the Commission shall determine an appropriation within 90 days of the written notification to the Commission of the existence of such dispute. The section shall not apply with the wells drilled deep and the reopening with the injection water, gas, other fluids, any subsurface formation. Alright, 652 units of the operation and pool. Upon application, any operated deep well productive oil or gas of the well for the mineral will be associated produced therewith with the notice given with the Commission. All person reasonable to know of their own interest, oil and gas will, after a hearing conducted according with the Kentucky Revised Statute, Chapter 13b of the Commission, may enter final order requiring the operation pool with any portion combination thereof with the field of the unit operation connection of the program designed with the void of the drilling unnecessary for the well, otherwise prevent waste and create the ultimate recovery of the unitized minerals by additional recovery method. The final order should provide for the unitization separately owned track with the inch of the pools or pools only after defining the order reasonably necessary for the prevention waiver of the proposed plan unitize with the operation create the ultimate recovery of the oil and gas both of the pool if economically feasible. Production oil and gas are both of the unitized pool with the allocated of the manner and share of the recovery all of the owner of the just equitable and share of the in production. With the contract incorporating utilization agreement that has been signed with when ratified with and approved by the owners, at least 75% of the interest of the pool cost shared under the terms of the order and 75% of the interest of the pool with production is to be allocated of the royalty in the unit area of the contract incorporating required agreements of the operation have been signed with a written ratified approved of the owners of at least 75% of the interest in the pool cost or share of the Commission have been found with has made a finding to the either effect either the final order or a supplemental order. Final order requiring the operation shall designate one operator unit of the shall also make with a provision proportional allocation operators cost and expense of the unit operation include with a reasonable charge of the supervision allocation shall be proportionate separately owned tracks over the production from the unit in the absence of the agreement to enter within the operator field with the Commission providing that the sharing of the cost of the capital investment with the well physical equipment and the intangible drilling cost. Commission should provide order by sharing the cost of the same proportion cost expense of the unit operating by any operators consented for the utilization for the required for the contributed cost expense of the unit operation cost of the capital investment well physical equipment tangible drilling unit except for the others proceed with the sale of the production accruing with the interest of the operator exclusive of the royalty overriding royalty interest. The Commission able to notice that him will provided above may but from time to time enter with the new and amending with a final order in a large unit area approving the agreement to adding with the area of the pool and portion combination thereof. Previously included new amended final order shall not become effective unless until all the terms of the provisions of the unitization agreement relating with the extension of the enlargement unit area and additional pools, the portion combination thereof of the unit or operations have been filled with the satisfy of the evidence thereof was submitted by the Commission. Extension of the addition effective with the order have then agreed with the writing and order at least 75% of the interest of pool with the share of the pools and pools portion combination thereto to be added with the unit operation order by 75%. Interest pools production allocated to royalty owners pools portion combination of evidence thereof and the substitute of the Commission. An agreement in providing for allocation production unit area shall first allocate each pool with an additional portion of the total production oil gas both to all pools affected by the area and alert allocation to be proportion contribution will be added in portion extension of the area expected during remaining course of the unit operation to total production oil and gas both the unit is enlarged remaining portion of the unit production shall be allocated among the separately owned tracts within the previously established unit or same portions are specified prior to the enlargement. At 653, share production of the drilling unit, unitized pool. Each operator shall have the right to take kind in and share of the oil and gas products of the drilling unit pools, unitized with the Kentucky Revised Statute 510, 520, 565, 610, 651, and 654, 700, and 353, 99.1. Operator shall pay with the expense of the allocation thereby and pay an account with the unit operator with the oil and gas fair value thereof that has not been paid share of the drilling completing operating costs. The section applies to the deep well drilling units only. Alright, drilling without consent of the landowner. Nothing contained within Kentucky Revised Statute 353, 510, 520, 565, 610, 651 through 654, 700, or not 353, 99, 1 shall be construed for the authorizing an operator with or without an order of the commission to drill upon, enter upon, use any manner of the surface of the land without consent of the owner thereof, the evidence for the oil and gas or lease. Otherwise, this section applies to deep well drillings units only. Alright, use of shackle rods related to cables prohibited. No operator shall utilize shackle rods related to cable to production of oil and gas. Display of danger signs on the oil storage of the well. Operator shall cause signs permitted with the word danger. Other information may be required of the department to prominently display with on all facilities use the storage oil, whether the facilities are in an active production or have been abandoned. Alright, 660. Report required for the termination operation contents confidential information. Person who permit issue with the pursuant of the Kentucky Revised Statute 353, 500, 720 within 90 days of the termination operation conducted under the permit with the Department of Transmit with the Kentucky Geological Survey in a form furnished for the Department following with the information relating to the copy of the drill log certified with the true act with the depth and thickness of the well waters encountered log, the deep, all showing the oil and gas depth of the thickness of all the coil seams encountered, a true copy with the electrical survey, similar log survey they take with the person with the permit issue obtained with a copy of the electrical survey, similar log survey, electrical form. Operator shall submit with the electrical survey, similar log, electric form is requested by the department. Upon request of the department, any person who permit issue shall save with the Kentucky Geological Survey samples with all the cuttings well drilled with deep in the pursuit of the period of 90 days after the completion thereof. Upon request, any of the person furnishing information under the section, information shall be kept confidential period of 1 year after the information furnished through such a person. Upon request, after applying a person applying for a permanent stratigraphic test well revision shall grant 3-year period confidential all of the drilling records by section on the day of the completion of the drilling of the well. Well record survey the logs conducted with the stratigraphic wells which are subsequently granted oil gas production permit shall comply with the confidential requirements of subsection 3 of this section. Alright, then we're going to read 6601 through 6606.